It's a little crazy with the kid and the dog.
I can't get my video to work today.
That makes me look adventurous.
Oh, sorry.
Oh.
I know. Oh no.
Welcome to Makeup That was so bad.
That was so bad.
Okay, cool. Hi, everyone. I'm just going to share a few quick little housekeeping notes, and then we can get started with Ron. So thank you again for joining us today. We had so much feedback and so many good things to say about Ron's session on Monday that we have invited him back for a new one. So we'll get started soon. But while we wait for everyone to join here for a couple minutes, please take a look at the code of conduct to ensure we're following community guidelines just to make this a safe and inclusive space. So to read the full statement, you can see the link that was just posted by our community moderator in the chat to the right. And I'll give you all a few minutes to review that, but also just take a moment to get familiar with the chat, the questions, and the polling functions for today. I actually don't think we have any polls, but the questions will be super important since this is a Q&A. Our community moderators are Tim Shadone and Spencer Tamakis, who will be posting relevant information and links into the chat, answering questions, and then please use the chat to communicate with other attendees and inform us of any technical issues. We've had a full house for our previous Bankruptcy Week sessions, especially Ron's. So I do want to let you all know we're recording everything. We'll post them to our Next Chapter YouTube page later today, and we'll email you all the link. If you're experiencing any connectivity issues, try closing all of your other programs, all other tabs, even maybe leaving the event and coming back in. And then sometimes Chrome works better than other browsers too. We've also created a free Slack group so you can continue the conversation. It's open to all Bankruptcy Week attendees. We encourage you to join a network. There are channels broken out by region. We already have a few hundred people chatting, so we'll include the link in our recap, but we'll also post it a few times throughout the session today as well. So thank you again for joining us today for our Ask the Expert with Ron Drescher. My name's Katie. I'll be the MC. But first, I just want to go over a quick couple of stats. So since the pandemic started, 3 million people are not paying their mortgage. 1 in 4 small businesses have shut down. We heard as of this morning, this number is actually up to 38 million people who have filed unemployment. So the economy is not going to be the same when we get through this, and that's why we came up with Bankruptcy Week. As a legal software company in the bankruptcy space, we've seen firsthand the data represented by the ebbs and flows of the economy. So during the last recession, bankruptcy filings went up 74%, and commentators are predicting a tsunami of filings after this pandemic is over, and attorneys need to be prepared. So this week is all about helping you learn bankruptcy and how to better your practice. So briefly, some of you probably heard this intro from Ron, but just to give you some background, he's been practicing bankruptcy law since 1985, even before he graduated law school. He is licensed to practice and has filed thousands of bankruptcy cases in California, Maryland, Delaware, Virginia, and Pennsylvania. His YouTube channel has 250 videos related to bankruptcy practice. He's written dozens of articles on bankruptcy, created numerous infographics, and has also authored 2 books, one of which is File Bankruptcy and Get Rich, and the other is The Single Mom's Guide to Financial Recovery. And those books have over 2,000 copies in circulation. So Ron will be joining us again tomorrow for a session on bankruptcy systems. That you can go to our registration page and sign up for that now. But for now, again, since Ron had such a popular session Monday, we had to leave a lot of questions unanswered. So we thought it would be nice to invite everybody back, and Ron can kind of pick and choose questions from the live chat to answer. So I would recommend only posting your questions for Ron in the questions tab. That's going to be a lot easier to track and manage for everyone. So I'm going to go ahead and invite Ron on stage, and he can take over and take it from here.
All right, can you hear me?
I can. I hear you loud and clear.
Perfect. Hi, how are you doing?
I'm good. How are you? You're like
Good.
Mr. Bankruptcy Week.
No, that's not right, because you have so many other great speakers and so much fantastic content.
We do. It's been a lot of fun.
I just think it's an exciting program you guys put together.
Yeah, it's awesome. Okay, well, I'll let you go. I'll be back in about 50 minutes-ish, and I'll close up.
Okay, that's great.
Okay.
Before I get to some questions, I thought that I would, I've noticed that lawyers want to know, how do you get the phone to ring? They've asked a lot of marketing questions. There's been really good marketing content here. So I thought I would spend a couple of minutes to provoke some questions about, things I've done to market my firm. And, I'm a big believer in content marketing. I want the world to think that, I know what I'm talking about when I'm, marketing my services. So I do have 250 YouTube videos. I did write these 2 books. I have blogs and infographics and newsletters. And one of the things that I haven't seen this week talked about is, in my opinion, the best way to start a new practice area is to email to your existing list. Everybody, I've seen a lot of comments on Slack and on the question box or on the chat box about how people have an existing practice and they want to add bankruptcy. That's fantastic, because you already have a list. You already have a list of fans, your clients and referral sources and employees. These are all people that should be referring business to you. But you have to educate them and let them know that you're in the business of bankruptcy law. This is going to be your first, best, least expensive way of generating clients. It's your own list. It's the diamonds that are buried in your own backyard. So I believe in drip marketing campaigns. I have a CRM, and I don't think, if you don't have Infusionsoft, I expect this slide to mean nothing to you. All right, but I'm just going to give you a brief idea of what it means. So here, on the 10th day of September, every year, I send to everybody on my list the NFL tailgate party infographic, and I got a little email that talks about it. And this, it's a thing they get towards the beginning of the season. On the 29th day of October, right around the World Series, I send out my blog on what is it about being a catcher that means that I did an infographic on the Baseball Bankruptcy Hall of Fame, and I wrote a companion blog about catchers. The fact is, a catcher has never filed bankruptcy, and I explain why and what, about how they get a view of the whole field, and they're planners, and they grind it out. So that's what this is. This is my annual drip campaign. I did a funny infographic, the Bankruptcy of Santa's Workshop, that goes out on Christmas every year. So, I try to keep in front of my list without being obnoxious. But, that's, to me, the best way to market your practice when you're getting started. And it doesn't cost anything, because you already have all of these referral sources. So, okay, I'm going to now start looking at the questions. Let's see what we got. I'm loading up the questions. All right. Sue, okay. All right. So, how do you list and value a life estate in debtor's primary residence, in which a third party, non-resident, has a loan and there is no equity? Okay, how do you do that? Me, I listed at zero value. Who would buy that? Who's going to buy that? That's the real question. If nobody is going to buy that, it has zero value, because what you're doing is you are romancing the trustee in your bankruptcy schedule, and you want that trustee to get a sense of, whether that trustee really wants to get involved in selling these assets. So I say it has zero value. I would write it has zero value. Who's going to buy it? Who's going to buy a life estate in a piece of real estate, whether or not there's mortgages or equity? No one's going to buy that, because how are they going to then transfer it? They're going to lose all of their rights the instant the life tenant dies. That's my answer to that. All right, let's see. When starting this, all our expenses feel paralyzing. Clio, next chapter, virtual parallel, but given the pandemic, we are turning to feeling. What's essential? What do we go with, and how can we build it as we go? Okay, that was from Lynn Holdsworth, and that's been upnoted 4 times. I think that the first and most important thing is a CRM, a contact relationship manager. That way you get all of your contacts in one place at one time, and you listen. And if you have an existing practice, then you have your existing clients. So get them in there and start emailing them. And that doesn't cost you anything except for the cost of the CRM. I use Infusionsoft, which is a CRM on massive steroids. I love it. It enables me. I use it for e-commerce. I use it for staying on top of my clients. I use it for reminders. So I strongly believe in that. Now, someone says, what if you don't, suppose I don't have an existing list? That was Paula Collins. Honestly, I think everybody's got some list, even if it's everybody you went to law school with. Everybody you went to law school with could be on your list, right? You could put them in there, make sure, if you want, if you're a little nervous about spamming people, send out an email and saying, hey, do I have permission to send you content? I would say, if you ever go to a bar, if you do any networking at all, and you get somebody's card, ask them right then and there, hey, I send out content related emails. Do you mind if I send it to you? I think that's the way to go. You do have a list. You just don't know that you have a list. So yeah, that's right. Everybody in your family could be on your list. Everybody who went to law school, your law school professors, if you've been practicing at all, other attorneys in the area. And you know what? Don't be ashamed to send your content to other attorneys. That was one of my first things that made me nervous when I started doing videos, thinking, all these other attorneys in the area are going to think that I'm bottom feeding. And it actually ended up turning out, years later, they would come to me and they say, you know what, we really admire your content marketing, because that was, I don't have the guts to do that. And I would say, yes, you have the guts to do that. You just have to convince yourself. All right. So Lynn, I hope that answered your question. Let's see. All right, 13. Desiree Vance wants to know, can you recommend materials for attorneys who have never filed a bankruptcy but want to transition into the practice to help the transition? How-to guide, practice guides, etc. Short answer, not really, because those, most practice guides, there's NOLO. NOLO isn't bad. That's why I created Complete Bankruptcy. Exactly for people who are in that situation. I had some people contact me ahead of time, and they said, what are the resources? I said, you know what? I should put this out there. Now, Katie just put up a call to action And if you've already done that, you don't need to do it again. I've been sending emails to the people who signed up, and over 300 people signed up, which is wonderful. That have had different items, and I hope you have found it helpful. If you sign up and you end up not wanting to go into it, that's okay. I'll continue to send you content, because I think that's the way to. I think that's an important part of marketing, is to add value and have people say, all right, you know what, this person has value. They're not just out to get me, to get money out of me. This is really valuable content. I don't have a short answer for that, but hopefully that will help you. All right, so let's see if what are your suggestions in dealing with elderly clients regarding competency concerns, medical and care matters, and their well-meaning children? You know what? That comes up a lot. One of the things about elderly clients, and this is both an estate planning question and a bankruptcy question, is, first of all, what are their sources of income? If their sources of income are just Social Security, creditors can never get those Social Security income streams. They can't garnish them. They can't seize them. If you've got a bank account that is funded solely with Social Security money, they can't seize that. The court will block that garnishment right away. So sometimes you really don't even have to file bankruptcy for them. But a lot of them and their well-meaning children want a bankruptcy for them because they don't like them to be harassed by creditor calls. So first of all, I strongly recommend advising them that bankruptcy may not be necessary, depending upon their situation. If they have equity in their home, you should consider a reverse mortgage for them. Talk to them about the pros and cons of that. If they're not competent, there are substantive bankruptcy issues regarding this, specifically concerning the credit counseling course. If you have credit counseling, the credit counseling requirement can be waived if the debtor is not competent. And so that has come up also with elderly clients. But I think the key is really to ascertain whether if they are competent, then they're your client, interact with them. But they most of the time want to have their children involved in the decision-making process. That comforts them. So there's conflict of interest issues that come up in bankruptcy all the time. These are issues that are going to come up. And if you have more questions about those, I'll talk to them about that. So Barbara wants to know, how long do we expect the tsunami of new cases to last? A year? All right. Well, during the recession, during the last recession, I think it lasted about 3 years. So I think that'll happen. Bankruptcy clients are a little slow to boil because there are still stigma issues. People are still going to try to dig themselves out without filing bankruptcy. That's one of the reasons why, in the last presentation, I think it was Jim was talking about having your intake process and staying on top of the clients. That's probably more important in the bankruptcy world than almost any other kind of practice, because they are slow to burn. So you do need to stay in front of them by adding value, not by nudging, but by just saying, hey, here's a blog I wrote. I wrote a blog about Martin Luther King Jr. For his birthday, and that goes out every year on his birthday, and it gets a lot of opens. People like that. So anticipate that a lot of clients, you'll talk to them, they won't sign up with you right away, but maybe they'll sign up for you in 6 months to a year. I got a communication today from a client that I saw a year ago. So, okay, let's see. It is my understanding that medical debts are joint debts between spouses. How do you handle medical debts when only one spouse wants to file bankruptcy? State law question. Are medical debts joint debts? If they are joint debts, all right, you have to consider that in filing the bankruptcy. I was never under that impression that medical debts are joint debts unless the spouse specifically guarantees. That's a state law question. It's not, it's, one of the issues when I was thinking about bankruptcy, in my early days, I was told that bankruptcy is a litigation type practice, and certainly Chapter 11 is like that. But I think, especially if you're doing consumer bankruptcy, it's more for the people who love their property course, because you need to know the rights and obligations under state law regarding a debt or regarding an asset, because that is going to dictate how that debt or that asset is treated in bankruptcy. All right, let's see. All right, Craig Waters wants to know, if you're an attorney entering the bankruptcy practice for the first time, is it feasible to handle Chapter 7s and 13s? Or would you recommend handling Chapter 7s for a period of time before taking on Chapter 13s? To me, there's no difference from the attorney standpoint, because the client's coming in, the client has a problem. Can you solve that problem in Chapter 7? I mean, you got that client right there. They're looking to you for an answer. I don't think you can say, yeah, you know what? I only handle Chapter 7s. I'm going to refer you out to somebody because I think it's a 13. First of all, you have to know for sure, is it a 13? Can you handle it in Chapter 7? I don't believe in that, although I do understand that attorneys do that. And listen, a Chapter 13, the no-look fee is in the neighborhood of $5,000 in many states. And then if you're willing to do fee apps, I charge $7,500 for a Chapter 13 when I do a fee app. I get $1,500 up front, and then I have $6,000 paid through the plan. And that's the $7,500 client. You really want to be referring that out? So is it feasible? Maybe it's feasible. I don't know why you would want to do it. I hope that answered your question. All right. Kim wants to know, what's a no-look fee? Great question. Chapter 13 cases, they last 3 to 5 years. And really, bankruptcy courts want people to remain represented by their attorneys for the life of that case. And when you are taking on that client, the bankruptcy courts will say, and this is in every jurisdiction, it's different. They'll say, we're going to deem a specific fee as reasonable, and you stick it in your and when you stick it in your Chapter 13 plan, and the court confirms that plan, then that's $5,000, whatever the no-look fee is, which is net of the deposit you get up front. They're going to say, all right, the Chapter 13 trustee will pay you your fee without having to file a fee app or getting any other approval. So that's why they call it the no-look fee. And I hope that answered your question, Kim. Richard threw in, what about referring out and fees after performing substantial other work? You have to write down on your disclosure of compensation whether you're sharing the fee with anybody else. It's not like a PI case. And the bankruptcy world really frowns on shared fees because it feels like it's going to get more expensive for the client. All right, Rachel says, fee app. What's a fee app? All right, that's a great question. A fee app is an application you file with the court asking the court to enter an order approving your fees. And what you do, and by the way, I talk about this a lot in Complete Bankruptcy. I've got fee app forms and techniques because it's really important. That's where you file this application explaining why everything you did was justified. You have to have a timekeeping application that will allow you to produce detailed time records. And I understand Next Chapter has that in their resource. I don't use Next Chapters, but I think I'm going to start looking at it just to see if it works for me. And you attach that bill to your fee application. You serve a notice on all the creditors and parties in interest. And the bankruptcy court might just approve it if nobody objects. Might set a hearing. You have to come in and justify your fee. This is one of the reasons why they don't like fee apps in Chapter 13. They really prefer to have them in. That's why they like the no-look fee. But I've lost so much money on no-look fees over the years that if I see the case is right for a fee app case, I'll do it, and it's usually worth a good $2,500 more than the no-look fee. Okay, all right. Tom wants to know about the small business subchapter 5. I can't wait to do my first subchapter 5, chapter 11 case. Because, all right, this is Tara was smart for not going into what I'm going to go into now. But I'm going to go into it, and it has to do with chapter 11. And one of the things that makes chapter 11 so challenging is that to make the chapter 11 work, you must have an impaired consenting class. That means that some creditor that is not getting paid according to their contracts, or some class of creditors that are not getting paid just according to their contract, are agreeing to the terms of your plan, whatever that is. And that's not always the easiest thing to do in Chapter 11 cases. The subchapter 5 omits that requirement. And I think it makes it much easier to confirm Chapter 11 cases. So I can't wait to do it. And I hope I haven't brought even more confusion in. But Chapter 11, you want to get into Chapter 7s and 13s, I say, yeah, full speed ahead, let's do it. Chapter 11s, take a deep breath before you decide you really want to get into that. Because even the small business subchapter 5 is super complicated. All right, let's see. Nick wants to know, what software do I use? I want to allow me to keep in contact with clients to guide them through the process. Wow, all right, so I use Next Chapter, which helps you stay in touch with the clients. I use Infusionsoft, which I feel very strongly about. And you know what? Next Chapter has a chat requirement, or has a chat functionality, or text messaging is really what I meant to say. Text messaging. Text message your clients. They love it. Clients love text messaging. They've all got their smartphones. We are all addicted to our smartphones. Your clients are addicted to them. They like text messaging more than they like email. So I say, yep, you want to be able to text message. I use Infusionsoft, and I do text messaging as part of the automated communications that I do with my clients. And I feel like that's just a great way to connect with them. All right, how do you determine household size? I think if you've got a child that's spending any significant time with you, and to me, if they're spending 2 or 3 days a week with you as part of a divorce, I include them. If they're off to college, I include them. You know what? Some lawyers and some trustees really like focus in on that. Where I am, they don't tend to focus in on that unless what you're doing looks extremely abusive. So I think you could be a little bit expansive about it. Don't try to sneak it by. If you want to say at the household of 4, one of them is in college, you can do that. You know, I mean, if it's a really, really close call, it's always good to let the world know what you're doing, but I'm okay. Karina wants to know, is a shared fee in a co-counsel situation going to be difficult? We'd be happy to share the fee on an early case in order to help compensate them for their guidance. I don't think that's a good plan, honestly, Karina, because they're just going to look at it. You know, oh, you're shared. You have to click a box on the disclosure of compensation. Are you sharing the fees? By the way, and please forgive me for plugging Complete Bankruptcy. I set it up because it's a part coaching, and it's a part coaching program. So you definitely want, yeah. I think your instincts are right to compensate a mentor for their guidance, because and that's part of one of the things that I am trying to do in Complete Bankruptcy is to create mentorship and create a mastermind, so that you'll be able to go in and ask me or any of the other lawyers that are involved in the mastermind. All right. And on cue, Katie puts up the I want to accelerate my practice. All right. Jim wants to know, how does one strip a second mortgage lien for an undervalued primary residence? Okay, first of all, you're in Chapter 13 or Chapter 11, but I've discouraged you from going into Chapter 11. I'm going to assume you're not there. Cannot do it in Chapter 7, which frankly, in my opinion, is illogical. But the Supreme Court said you can't do it. So there you go. And one of the nice things about bankruptcy cases is that you don't tend to get involved in all this crazy political back and forth in Supreme Court cases. They don't tend to split along party lines. That's kind of nice. All right. So strip a second mortgage lien for an undervalued primary residence. First, you need an appraisal. You could try Zillow. You could try a realtor. Sometimes I feel a little bad asking realtors to keep doing freebies for me, but they've told me they don't mind because these are leads. Eventually, these people are going to sell their home, and this is a lead for them. What they typically do is they'll do online valuations, and a good one will go to the house, which is smart. Get to know the homeowner and let that homeowner be in their drip campaign. Let the homeowner be on their list. So you need a value, and you need, and it's not an auction value, it's not a quick sale value, fair market value. And then what you need is a document that shows how much is due on the first mortgage. I mean, that's usually just the mortgage statement. And then you want to talk about what's due on the second mortgage. And the value of the house needs to be less than the amount due on that first mortgage lien. If there's $1 worth of equity for that second lien to attach to, you can't strip it off. It's sacred cow. You can't modify a mortgage secured solely by a principal residence. So hopefully Jim and the others who upvoted that question, I hope that question. Now, all right. So that's the substantive answer. The procedural answer is, okay, depends on your jurisdiction. In Maryland, you can do it through the plan, but you don't want to do it through the plan because then they will absolutely call your case when it comes up for confirmation instead of what happens in most jurisdictions, which is you don't have to go to court, you don't have to get the case called. So in Maryland, they don't want you to do it through a plan. But a lot of jurisdictions, they do want you to do it through a plan, and you check off the boxes. Maryland, they want you to do it by a motion, which you got to make sure that you file that motion and you serve it on the creditor. You need to serve it. If the holder of the second mortgage lien is a depository institution, then you got to serve it by certified mail on an officer of that institution. I always serve the CEO at their corporate headquarters. All right, now I'm gonna kind of deviate a little bit about one of the wonderful things about the bankruptcy practice, which is if you need to file an adversary or you need to serve somebody, do it by U.S. mail, which is one of the reasons why the U.S. mail has to survive, if just for the bankruptcy world. But you serve them by U.S. mail. You don't have to personally serve them. You don't have to hire a process server and go out and do that. And most people, you don't serve by certified mail. Just serve them by regular mail. Even if you're serving the United States of America, send it out to William Barr by regular mail at the Department of Justice. You have to also serve the local office. But yeah, you know what? Regular mail. I mean, how great is that? And a lot of people think that they're not served if they only get served by mail. They're served. They're served. So to me, that's a great part of the bankruptcy practice. Now, I'm gonna give a plug to a company called certificateofservice.com. It's also bkattorney.com. And they do bankruptcy mailings for you. They charge you 15 cents a page and the actual postage. And if you do the complete bankruptcy program, they have freebies and discounts for you. One of the reasons why that's important, especially if you want to get into the bankruptcy field, is that if you file a plan, an amended plan, and that happens in most Chapter 13s, you have to serve it on all parties in interest. There's a lot of stuff you have to serve on all parties in interest, especially in the Chapter 13 practice. Your staff is going to get bogged down in doing all of these photocopies and printing out the postage and stuffing the envelopes and sticking them into the mail. To me, I think that's a terrible use of your team's resources. I believe it's certificateofservice.com. Rachel wants to know if complete bankruptcy covers Chapter 11. It does not. But if I have enough interest in it after people get part of the program, I'll do a module in Chapter 11. I expect to do a small business Chapter 11 module. But right now it covers 7 and 11. All right, let's see. Client wants to file Chapter 7 but hasn't filed tax returns in 7 years. Can he file bankruptcy without filing returns? All right. Technically, yeah, probably. I don't think he's going to get a discharge, though, without filing for the tax returns, because the trustee's going to want to see him. U.S. trustees probably also going to want to see them. So I'm not going to file tax. I won't file a case if the client hasn't filed tax returns in several years. To me, that's just a tremendous red flag. I mean, look, you're going to need the tax returns. You're going to need the pay stubs. You're going to need bank statements. And then there's a bunch of other things you're going to need. Documentation. They haven't filed tax returns in several years. I think you're looking at a problem there. I think that is a problem client. And we make it clear, yeah, you gotta get these tax returns filed, or prove to me that you were excluded. All right, how do you know when a case? Floor wants to know, how do you know when a case is worth doing a fee application? What do courts look for to approve the additional fees? Okay, if I've got a high income debtor, where the debtor is essentially paying my fees, I always do a fiat case. If I've got a debtor that has substantial equity in their property and they're in a Chapter 13 because they have to buy back that equity, I'll do a fiat on that case. If I've got a client that's got a running business, if I've got a client that has multiple properties, those are cases. If it looks to me like it's going to be a little bit more complicated, I'll do a fiat case. If I've got a client, like I have a client that filed the Chapter 7, got a discharge, gets themselves into a problem. Now they need to do a Chapter 13, and it's going to be a 13 with the lowest possible payment. I'm not going to do a fiat in that case. I'll do the no look fee. So a lot of it will depend upon if the client is paying for my fees or if the creditor is paying for my fees, and that's not something that might be like really understandable at this point. But I mean, for example, let's say, all right, there's a concept in Chapter 13 called the plan base. And the plan base is the dollar amount that you are promising to pay through your plan, aggregated over the life of the plan. So if you have a 36-month plan at $500 a month, that's $18,000. That's your plan base. So there are certain payments that get priority for the plan base. One of them is attorney's fees. So let's say you've got a client that's a high income client and they're paying $1,000 a month after running all of the numbers over 60 months. That's $60,000. That plan base should be able to support my fees. If they've got debts of $80,000 or $90,000, which is common, those $80,000 or $90,000 worth of unsecured debts, they're going to share pro rata in what's left of the plan base after you pay, attorney's fees, trustees' fees, priority taxes. So to me, the creditors are paying my fee, not my client. I'm going to do a fiat. Now, let's say that the plan base is $10,000. Well, I don't feel right, asking and priority tax, priority claims, and attorney's fees are like $11,000. I'll do the no look fee. I don't feel right having my client pay, the extra for the fiat. It's a tricky question to answer if you're not like enmeshed in the Chapter 13 world, but I hope that's helpful. Hey, Katie, how you doing?
Good. So we have an idea. If you can click on the questions tab. And
I'm on the question tab.
There's there are different order buys. So if you click on upvotes.
Right.
Can you do some of the top ones? There's a ton of votes on some of these.
Okay,
so that Janine has.
All right. Is there a way to prioritize it so that only the top ones come up? Order by upvote. There it is. I see.
Cool.
Oh, okay. All the columns. Can you give us a ballpark figures on pricing for each chapter of bankruptcy? Short answer, no. Longer answer, because it's different in every jurisdiction. In Los Angeles, you can get away with, I think $3,500, $4,000 for a Chapter 7. I think that I don't know. Nobody's going to look twice at that. You can't get that in Tennessee. There's no way. So it depends on the jurisdiction. What I suggest is that you do a little survey, find the top filers, go to the disclosure of compensation that they file on Pacer, and look at that. Pricing of bankruptcy services is an art. It really is an art. All right. So, and for Chapter 13, you find out what the no-look fee is. Can you recommend attorneys who have never filed bankruptcy want to transition into practice? All right, I answered. That was Desiree. Do you ever use a CPA to help you review the data? Sure, I use the CPA. But usually it's not really necessary for consumer cases. Those are few and far between. Can you recommend materials? We did that. All right. Best way to know a ballpark figure how much the client, how much client will be paying back in a Chapter 13. Yeah, that's right. Lizzie wants to know the best way to know a ballpark figure how much a client will be paying. You know what? There are some ways. There are some jurisdictions that require clients to pay something to general unsecured creditors, but most don't, and the bankruptcy code does not require that you actually make a disbursement to unsecured creditors. There's no quick answer to that because you have to consider, well, are there taxes? Are they behind in their mortgage? People who signed up for complete bankruptcy after my Monday session, I've sent a series of emails during the week talking, just trying to comment on what came up during the prior session. And for one of them, I offered a planning worksheet, which is an Excel spreadsheet that's color-coded. I imagine that if you're not familiar with Chapter 13 and you saw it, you probably got a headache. So I would urge you, if you got it, you looked at it, to take a closer look, because I do explain how that works. And yeah, clients want to know during that intake, what am I going to pay in my Chapter 13? And so I talk about that a lot in complete bankruptcy because it's really important. And if you sign up for complete bankruptcy and you're going to get that download, even if you sign up now, because I have that as part of I have a drip campaign for people who signed up for complete bankruptcy, who they were interested in the information. And that's the tool that I use, because it's a complicated answer, because you have to consider taxes, and you have to consider equity in the house, and you have to consider if they've got priority taxes. So there's a lot of issues that you have to go into to determine that. But yeah, I spend a lot of time talking about that in the course. And the download, it was a free download. Everybody, like I said, who signed up on Monday has already gotten that. And if you sign up now, you'll get that in 3 or 4 days. Okay, so let's talk about some other. What's the best way to determine if a client qualifies for a Chapter 7 or a Chapter 13? All right, on my bankruptcy basics, I talked about 9 reasons why you would file Chapter 13. And if none of those 9 apply, you're going to a Chapter 7. So I'm mainly looking at what your income is. I'm mainly looking at your, if there's equity in your property. I'm mainly, if there's no equity in your property and your income is below the median for your state, for your household size, I say, yep, full speed ahead, Chapter 7. Just make sure that they haven't filed within the last 8 years. All right, let's see. Chris Williams wants to know, if a debtor indicates they owe a tax debt, is it your opinion that a tax account transcript must be pulled prior to bankruptcy filing every time or only sometimes? Yeah, if you could do it every time, great. But not every, if somebody says, yeah, you know what, I owe for 2018 and 2019, here are my returns, I don't think I owe for prior years, I don't pull a transcript every time, not for that. They say, yeah, I owe for 2013, especially if they owe for a year that I think would be dischargeable in the bankruptcy, I definitely want a transcript. Absolutely, unquestionably want a transcript. If it's a Chapter 13, hey, the IRS is going to file a claim. Usually on day 1, they're going to tell you what they think is priority and what's not priority. So I don't know that you need a transcript in that case. But if I'm going to want to try to discharge debt in a bankruptcy, yeah, I want a transcript. I hope that answered your question. All right, do you use services such as the financing service featured earlier today? I don't, Dawn. That was from Dawn Bowie. But I do bifurcated. I do bifurcated cases. I think it's really important. I haven't used the financing service for many reasons. Talk to the U.S. trustee in your jurisdiction, find out what they have to say about it. Not every jurisdiction approves of bifurcated cases. Bankruptcy world is finicky when it comes to client fees. They really are, and some are much more sophisticated than others. I would say in some of the more rural jurisdictions, they are going to be very negative on that. I think the more sophisticated the jurisdiction, the more comfortable they are with those financing companies. But I'm not saying a bad thing about it. The question is, do you want your clients to be done by a financing service? That's a question you have to ask. And if you're saying, yeah, it's okay, it's the modern world, so the question is, what kind of relationship do you want to have with your clients, especially if you want referrals in the future? You think a client who is now not dealing with your firm anymore and is being done by a financing company because they've come up on a hard time, and so the financing company is dunning them, are they going to refer a case to you no matter how good a job you did? You can answer that question for yourself. All right. Let me see. Let's see. I talked about the ballpark. Do you ever use CPA? Can recommend materials for attorneys never file bankruptcy? I don't think there are wonderful materials out there. That's why I created the course. I hope I answered your question, Lizzie, about the best way to determine a client qualifies for Chapter 7 of 13. I feel like I come up lots of conflict of interest issues because representing creditors and debtors. Got to be careful. You got to choose your side of the street. If you want to represent Bank of America, Wells Fargo, Truist, the big banks, you're not doing debtor work. You're just not. At what stage of a new bankruptcy practice would you need to consider taking on staff? You must have a legal assistant, in my opinion. You must have a paralegal, in my opinion. I don't have an answer, but you don't want to be involved in collecting the documents and preparing them, because that means you're not selling, you're not doing the legal work. So I would say pretty much right away, especially if you could do them virtually. I mean, you can do them virtually. You could have these people on your team in a piece basis. All right. Crystal, you got to have. Crystal Laporte wants to know, when a married individual files an individual petition for bankruptcy, what, if any, cooperation or information is required from the spouse? All right. You must get their pay stubs. Must get their pay stubs. All right. So, all right. So I'm going to just talk for a little bit in the last few minutes, because I think I answered most of these questions. If I am planning on practicing 5 to 10 more years, does it plan to make sense to add this area to my practice? Yes. Yes. Big capital letters, exclamation point, underline, bold, italics. Yeah. 5 to 10 years. Absolutely. Absolutely. All right. I want to go back to my media. All right, babe. All right, back to my media, and we're going to talk about, I want to go into some more. All right, so complete bankruptcy, I talk about systems to help follow up on the leads, appointments, no-shows, no hires. I'm going to talk about automating the communication with clients for document collection, trustee meeting reminders, other milestones, practical strategies for analyzing Chapter 7 liquidations, solutions to the difficult cases, capturing uncertain clients. Detailed forms are included in the program. All sorts of promotional materials that you're going to want to put in your drip campaigns to your clients and prospects. This is what I did when I had too much time on my hands. I've got about 10 or 12 of these that clients like getting and people on your list kind of like getting. They're interesting. The course It involves coaching. I have a proven method for obtaining client testimonials, which is probably the most important thing you could have in marketing your practice. So this is the complete bankruptcy course. And if we could throw on that call to action one last time, if you think that's worthwhile for you, I think that's well worth doing.
I'm on it.
Thank you, Katie.
I will do it now. Yeah, that's
All
great.
right.
There's a lot of positive feedback in that chat too of people, and they think that they should sign up for it and they can really get a lot out of it. And I will say, being on like the support and the sales team at Next Chapter, I've worked with a lot of attorneys, thousands of them. Ron's a good one. He knows what he's doing. I would trust him to do my bankruptcy. So
Go ahead.
there's
Go ahead
some
now.
out there.
You're not on. You're not on.
But yeah, so great. Thank you again, Ron, so much.
Oh, this was totally my pleasure. My wife just came in.
Oh.
She's a little camera shy. So, but that's all right. This is my pleasure. I enjoyed it. I'm sorry that I don't have more time. These are great questions.
Yeah, there's a lot.
This is just great questions. It's a complex practice area. It's not just filling in forms and you know, but it's a great practice area. You really help people. You know, I have people that come to me, and after the initial consult, over and over, this happens every week. They say, you know what? I'm going to be able to sleep again tonight. I mean, how often do you get to hear that?
I know, it's so nice. It's such a taboo subject, but it's like, get rid of the debt, live with a peace of mind, and they can have people like you that they can trust to get them through that. That's awesome.
Right. You know, right before this, the people who had already signed up to get more information about the course, I sent them an email that had the first chapter of File Bankruptcy and Get Rich. And, you know, that's an eye-catching title. And by the way, if you sign up for the course, I'm licensing that book to you as a lead magnet. You know, put on your own cover. You know, write a preface. So, File Bankruptcy and Get Rich by Ron Drescher, prefaced by local attorney. Use it as a lead magnet. It's a great. I mean, it definitely attracts attention. I've just gotten thousands of leads from it.
Awesome. Cool. Well, thank you again so much. This was a very good conversation. You answered a ton of questions, and you get to grace us with your presence again tomorrow.
I can't wait. This is not Ron Drescher week, and I'm sorry that anybody ever feels that way. You know, what you guys have done, first of all, in creating your product, which is a phenomenal product. I mean, I'm so excited about the product. It's great. And then in putting this on and making this available for free, I just think what a great organization.
I know, it's been crazy. It's fun for sure.
Yeah.
Okay,
absolutely.
Great. Well, enjoy your evening. I'll leave this up for a little bit just in case people want to ask more questions, chat a little more. And then I will see you tomorrow.
We'll see you tomorrow, Katie. Thanks so much.
Good night, everyone.
All right. Bye-bye.